Good afternoon, everyone. My name is Dawn Bauman, CAI's Senior Vice President of Government and Public Affairs. Welcome and thank you for joining CAI and the fellows of the College of Community Association Lawyers for this important webinar on community associations and the coronavirus. I'd like to thank our presenters, Laurie, Poole, and Bunn. Attorneys, thank you so much for joining us. Attorneys who are fellows of the College of Community Association Lawyers and both on the Board of Governors. The information that we're providing you today in the webinar is not legal advice. While these two brilliant lawyers will be sharing their wisdom with us, they don't have familiarity with your governing documents, your community circumstances, and perhaps your state and local laws that may impact the decisions that you make. However, we're hoping that you use this information to help your community develop a plan of action for dealing with your unique circumstances as you plan for the challenges related to the coronavirus. Before we start, I'd like to provide a little bit of information about the technology we're using and then give a brief overview of the format for today's webinar. First of all, the technology that we're using will allow attendees to be able to submit questions to the presenters. On the control panel on your computer or on your smartphone, there's a tab titled Questions. Please feel free to type in questions during the presentation. The last half of today's presentation, we will start answering those questions, and we hope to get to most of those questions. Some of the questions may be answered during the presentation. That's okay. Still, feel free to put those questions out there so that we can answer them a bit later. Which leads me to the format of today's webinar. The first 30 minutes of this webinar will be frequently asked questions presented by Laurie and Brendan. These are questions that they've heard and other community association lawyers have heard throughout the country in the past couple of days and past couple of weeks related to how community associations are dealing with some of these challenging circumstances with the coronavirus. At the end of the webinar, I'll come back on and facilitate the question and answer session. I'll also share additional resources that CAI has available to continue this conversation and to help answer questions in the coming days and the coming weeks. These are challenging times. These are interesting times. And I can say this is our third webinar on this topic. And we've had new questions and sometimes new answers to the same question just in recent days as things are changing so quickly. So bear with us. Thank you for being here. I'm going to turn it over to our presenters who are graciously with us today, Laurie Poole and Bunn. Thanks, guys. Thanks for being here.
Thank you.
It's our pleasure, Dawn. And you know, sometimes it's changing circumstances that might give different answers to the same question, and sometimes it's the fact that lawyers are the ones answering those questions. We are in definitely interesting times at a minimum. But listen, both Laurie and I, and by the way, I'm a lawyer from the Washington D.C., Northern Virginia area. Laurie is a lawyer from California, so we come at it literally from opposite coasts. But we certainly have seen the same kind of angst and uncertainty that is kind of permeating our entire society right now. We have economic uncertainties. We've got personal ones. And we can see that from our client base. And I can tell you all, to the extent you have those things, you are not alone. Associations all over the country are asking the same kind of questions that Laurie and I will be talking about today. And I'd like to throw in this other notion. I mean, one of the great things we're seeing now is that people are being asked to stay at home, which in my view actually shifts a lot of the burden of what we're all dealing with as a society right squarely onto your shoulders, the shoulders of community associations. These are your homes. So that makes it, I think, a little unduly difficult on our client base. But listen, you all have been in difficult positions before. Community associations make difficult decisions on an ongoing basis. But you have the tools always at your disposal to exercise good business judgment. You have access to expert advice, you have your managers, and I would encourage you that as you work through these seemingly more difficult issues than usual, to use the same kind of process you always use when you're asking and answering difficult questions, and to rely not on just your experts, but rely on each other as well, especially in a time like this. So listen, as Dawn mentioned, this is not legal advice. Laurie and I are not familiar with your documents, and some of the questions we may get may not even be from the states in which we practice. So please do remember that you have an expert presumably in your own backyard. You have your own lawyer for your association. So feel free to reach out to your law firm. I think they would appreciate that, and I'm sure would be happy to give you good advice as you deal with these difficult situations. So Laurie, why don't you lead off with the first slide that we have?
Sure. So there, here, as Don indicated, that we all have been receiving very similar questions, even across the country, in this unprecedented time. So we came up with a list of some of these questions that were being asked, the frequently asked questions, and those are what we're going to talk about for the first 30 minutes and then answer your questions. And I echo what Brendan said about the theme is really continue to use your good business judgment. Understand too that, I mean, this is an evolving situation, and some of the things we were really grappling with even last week, we have clear direction given what states and the country has, the actions that have been taken. And so what we say today may be different in an hour, may be different, tomorrow. So just understand that it is continuing to evolve, and keep yourself informed. And like Brendan said, reach out to your experts and your state's resources for specific guidance. But the first thing is communication with residents. And yes, this is a challenging time, but this is also a time to remember that you are a community. And this is an opportunity for your community to come together and to further the main objective here, which is to protect everybody's health. That is really the objective of today, of this situation, why we're all at home, is for the health of and welfare of our residents. And this is your opportunity as managers and board members to further that goal. And remember that it does come down to community, and that as a community, you can work together to do that. And so it starts with communication. Certainly communication from the board to the residents as far as specific information about what may be affecting your community, whether you have suspended certain services or postponed certain events like meetings. We'll talk about meetings in a little bit. That should be communicated to your members. Your communications should be clear, they should be concise, and they should be consistent in whatever method you choose to deliver those communications. The communications can also be an excellent resource for your homeowners as far as information pertaining to your city, your county, your state. Perhaps if your communications are in electronic format, have links to those helpful resources. CAI has an excellent page right now, a couple of pages as to what all the states are doing, and they're keeping it updated. So certainly link to that. And in your communications, one of the questions is how how should these communications be provided to your members? You certainly need to remember who your audience is, who your membership consists of. If you have a community that is used to e-blast and email communications, continue to use that. If you have a community maybe with some older residents that aren't on email, you're going to have to be a little bit more creative, maybe phone calls, a phone tree, something like that. If you have a lot of people in your community that are likely volunteering to help one another, so draw on those resources, those volunteers, perhaps to make some phone calls if your community is not email savvy or have a website. If you have a website, certainly if you can update it, have a page on coronavirus like the states have, like the cities have, like the counties have, and like CAI has. And continue to, if posting in the community is still an effective means of communication, do that. Make sure you're taking steps to disinfect whatever you're posting the notice on. And we certainly don't want to be encouraging your members to gather in large groups around the mailbox or bulletin board. But for some communities, that is the most effective means, and that's the important point here: is use the most effective means to get communication to your members. But do communicate with them. Give them a sense of reassurance too. Yes, this is difficult. We're going to get through it, but that you're here for them. So, Brendan.
Right. I just
Yeah.
wanted to throw in one thing about communication. I had a client over the weekend that was insistent on having some sort of virtual town hall for their community, because he just said people need communication of some kind, even though the board had not yet resolved what the message was going to be, what their policy was going to be on certain issues. I mean, one of the keys here is to make sure you've got a unified, consistent message that's clear and, as Laurie said, reassuring. If you go in and you don't know what your policy is, or there's disagreement among the directors, not the best time to communicate. So make sure that your message is locked down and crystallized so that you don't give mixed signals to your community.
Yeah.
Our next slide here is about guests. This is a question we are all getting in my practice group. And I think it's one of the harder issues. And the real core question is, can we as an association limit the kinds of guests that are coming into the community, in particular in a condominium building or a high-rise building where you tend to have just more density than other kinds of community associations. And listen, in the time of quarantining, we would all hope to have a minimum number of guests. But the reality is most governing documents don't give a ton of discretion to the board of directors to limit the kinds of guests that are brought in by the residents. And that's not necessarily a bad thing. You wouldn't want your board passing on who's an acceptable guest in most circumstances. And this is kind of no exception. I have a few boards that have talked about whether they should try to limit people limit guests to those who don't have any symptoms. And I like the notion of it, but I think we get into a slippery slope when we are trying to define who's an acceptable guest. And let's face it, enforcing that could be nightmarish. So we do encourage all boards not to make a rule that you don't have a way to enforce. I think probably the better formulation for this kind of issue is to encourage your members through an affirmative release or communication to the building that they should take the lead in making sure that the guests that are coming to the building are appropriate given these circumstances. Encourage them to use their best judgment to minimize the spread of this COVID-19 mess into the building. Put the onus back on your members, because I do think it's going to become increasingly hard for boards to actually pass a rule that deals with this. I do think a good idea could be to encourage your owners to minimize any outside unnecessary non-essential projects that are going on in their units. This is not the greatest time for a kitchen renovation, obviously. That just draws extra contractors and guests into the building. So I would consider encouraging your members to do that as well.
Yeah, I agree with Brendan on the limiting of the guests, and certainly, yeah, well, in general, I agree with Brendan. And certainly the not making a rule that you can't enforce. So I've seen things about we want to limit, and remember too that fair housing laws still apply. I've seen things about we want to limit certain, maybe certain age groups of guests. That's going to probably fall into fair housing problems, discrimination claims. So you need to remember that those don't go away right now. So the next question, I've been getting a lot of questions about meetings, board meetings and annual meetings. So for board meetings, what I've been telling clients right now is where if you can't meet in a manner that's going to meet your state or governing document requirements, and we in California have very specific laws regarding open meetings for both the board meetings and the membership meetings. And if you can't meet those requirements, try to push any non-essential items. Let's postpone that. Let's see where we are perhaps in 30 days and see if we can't at that point gather again and have those meetings that do comply with our state laws and our governing documents. But there are going to be some things that are essential. And in that case, do what you can to comply with the law. As Brendan indicated, we're figuring out now what technology can do for us and to facilitate those board meetings and those membership meetings. So take advantage of that. CAI has some resources. There's a lot of online meeting platforms. I had a board meeting yesterday morning, all video conferencing. It worked out really well. So explore those, but push anything that's not essential if you can. If this is going to go on though for months, several months, then you're going to have to do your meetings. And I would say do the best that you can to comply, but understand that there may be some things that you can't comply with, and certainly consult with legal counsel. Annual meetings as well. I mean, California, we just passed legislation at the end of last year that became effective this year that drastically changed our election procedures. So we've been all rushing, cramming to get those new election procedures in place to have our annual elections in the first quarter for those associations that want to do that. And now we're looking at postponing them. And the associations went through a lot of rigmarole to get to that place. And some boards don't want to postpone those meetings. But again, I'd say if you can postpone it, if it's a non-contested election where you have the same number of directors or candidates running for the same number of positions, maybe go ahead and open those ballots, see if you can live stream the opening so your members can witness it, if that's a requirement in your state. But consider postponing it so that again, maybe 30 days, 60 days, so that you can have that in-person meeting like we're used to doing. But I have communities that some are postponing, some aren't, because they want to get their annual meeting done. Brendan?
I would just think that if you have to postpone your meeting and we're in the middle of a national emergency where people are not supposed to gather together, even if you're creating a small technical breach of your documents, I think in most jurisdictions, a judge is not going to hold an association accountable for that. I think there's a great defense to the board making a business decision that might be slightly at odds with its documents. The other thing I wanted to add is I'm in a jurisdiction where there's supposed to be a lot of transparency in meetings. And I have a few of my clients that are now doing virtual board meetings where they allow owners to phone in to observe the meeting via audio. And then they've got a separate number they use for their closed or executive session. So there are ways to deal with this, especially given, as Laurie mentioned, the technology available to all of us now. So this is the time to take advantage of that. The next slide and the next question we get is dealing with common areas throughout the building. Now, it's very easy, and most management companies have already given the advice to take some of the basic steps you can to make your common areas safer. More frequent wipe downs of equipment and commonly touched surfaces, the availability of hand sanitizer and wipes throughout the building if they're available, of course. But one of the big questions we get is whether or not an association should or could close certain facilities. I mean, let's face it, certain facilities are more conducive to people gathering in close quarters, and that's exactly what we're all supposed to be avoiding right now. So if you have a small gym that's frequented by a ton of people, I mean, I have a lot of clients that have elected to close those facilities. In my experience, most governing documents are pretty clear that a board has the requisite authority to manage, supervise, and administer those areas. So there usually is not a question about the board's legal right to be able to close the facility. So I think in most cases, an association board making that decision is going to be on good legal ground. I do have a few clients that are keeping certain things open because they think that the facility is appropriate, that social distancing can still occur. Even with those facilities, we would encourage our boards and our managers to make sure that you're carrying out the kind of extra enhanced cleaning protocols that will help promote the cleanest possible area. And again, if you make the business decision to close it, I do believe most communities are understanding of that right now. And be very honest with your community. If the board believes the gym or the fitness room or the yoga room needs to be closed, lay it out to the owners, explain exactly why, and make the case for it. I think most people will understand a board making a difficult decision in these difficult times.
Yeah, I think what I've been telling clients is, again, remember too, the objective right now, protecting everybody's health. And so boards are going to have to make a decision that might impact certain members, such as closing the pool, but it is in furtherance of the overall objective, which is to protect everybody's health. And, I get on the question about the pools closing, yes, the CDC has indicated that there's no evidence the virus can be transmitted in the water. I'm not necessarily worried about the water so much. I'm worried about the people who are going to the facilities, touching the gates and the shower handles and all of that, and that it could be spread that way. So that's the reason for that. And here in California, or at least in my county, they're closing the public beaches. They're actually saying the public beaches are closed because too many people are not adhering to the social distancing. So
Are these the spring breakers, Laurie, or is that only Florida?
it may be. The beaches, it was nice this weekend, so the beaches were
Right.
packed and now they're closed. So, so again, yeah, it's inconvenient. It's not fun, but it's for the goal of protecting everybody's health. We're getting a lot of questions about assessments, about do we continue to collect delinquent assessments? And I've actually had several clients say, can we stop the assessments for now? Can we give our homeowners a break and stop collecting assessments? That's going to depend on can you financially afford to do that? The association's bills probably aren't going to stop. And in fact, some expenses for the association may increase, such as cleaning service or janitorial fees. So be very careful about making a decision to stop, assessments for a period of time, because the association's expenses may not go away and might increase. But as far as addressing delinquent assessments, yeah, we're going to be hit hard economically. I think a lot of people have already felt it, and I think more and more people are going to feel have some economic implications, adverse implications because of this. So you're going to have homeowners that are probably going to become delinquent. Homeowners that are usually diligent in paying are probably going to become delinquent. We certainly would recommend at this time waive late fees, waive interest, but you can't really necessarily dial back on collecting the assessments. We're saying you still want to, for those chronic delinquencies, you should still protect the association's rights. And if you're going to do a lien's going to protect you from a future bankruptcy or other situations. So considering perhaps doing those, but certainly right now hold off on foreclosures and, like I said, waive those late fees and collection and interest. Brendan, what are your thoughts on the assessment question?
We all went through this back in the 2008-2009 timeframe, where there was just a lot of economic upheaval that was causing major issues with our owners. And I do think that it's hard to predict at this point what we're going to face now. This could be a few months. It could be 18 months. It's hard to know. I think in the short run, well advised to be flexible in payment plans and late fees and all of that. Don't miss your lien deadlines. In most jurisdictions, you need to continue to follow those. But I think the board for now can afford to be somewhat flexible, and we'll see where we are in a few months. And if it's a bigger, longer term problem, then we may have to look at budgeting for more bad debt than you normally would to get through this difficult time. So
another question I've gotten related to assessments is I've had a few communities that were on the brink of imposing a special assessment for a certain project. And they're asking, should we postpone that? We'll talk about a project that the association is doing, but I've been telling clients, yeah, if you can, this is not the time to impose a special assessment, recognizing the economic reality. One client, it was an emergency assessment for a safety issue, so they're proceeding with it. Other clients are saying, no, this project, this renovation, this painting project, whatever, can wait. I've also had clients that have said, we imposed the assessment, the special assessment, we collected the money, but now we're postponing the project. Do we give the money back to the owners? And again, that's going to be a conversation between your community and your attorney, what your laws are or your governing documents say. But those are some of the questions that we've been getting as far as the special assessment. So if your community is in the midst of a special assessment, that needs to be thought about at least in how you want to address it.
Right. If we could go back to the slide on pending contracts and construction, that is one that's kind of hard to answer in the abstract, whether an association that's in the midst of some sort of a renovation project or something might require it be continued. It's going to depend on the industry involved, what kind of work is involved. There are situations where the project may be able to be completed. Other times, because of the availability of the employees for the contractor, it may be that the association and the contractor need to work out a work stoppage agreement, or it might be that the contract already addresses the rights of the parties with respect to that kind of a situation. So you're gonna have to be a little flexible to look at all of the issues holistically with your contractor and try to work this through. I have one of our clients in my firm was in the middle of a fire sprinkler reinstall. They were almost at the tail end of the project, and they were forcing owners to leave their homes for a day while they sprayed in some special foam. That was a messy situation. They got through it ultimately, but this is a time for creative solutions and working together. And it's not all about whether you can force your contractor to keep working, and maybe your contractor can't get their employees to come in because of the various stay-at-home laws that have been, or orders that have been put into place. So that one's, you really need to look at your contract, look at your contractor, the type of work it is, and work with your lawyer to figure out the best strategy for your particular community, I think.
Yeah, and again, looking at safety, if it's a safety issue, or if you're in the middle of a project where the elements are exposed and need to be protected, you're certainly going to want to continue with those. But you do need to, take into consideration, do we want extra people on site and around our residents, and potential, everyone that comes in is a potential, could be bringing the virus with them. You don't know. So I think, again, like Brendan said, this is going to be case specific and really considering your community and what's best for your community. So we've had some questions about quarantining residents. Can we require our residents to be quarantined? Brendan will talk next a little bit about what if we find out there is a confirmed case in our community, but this is just more generally about, can we enact rules that require our residents to be quarantined? And again, it goes back to don't create a rule that you're not willing to enforce. One thing we have discovered in this in this situation is that the HIPAA laws, that is the privacy for health information, they don't apply to community associations. That being said, we're not advocating that if you should happen to get medical information about a particular resident, that you blast it all over the community, fire up your next door and start sending it out. We're advocating against that. But to the extent that associations wonder, do HIPAA laws apply to us? No, they don't. And as far as quarantining, I think referring your residents, your members, to CDC guidelines, state guidelines, city and county guidelines and orders that are in place are really what the association's role is to just remind everybody to follow what's been implemented in your particular area as far as quarantine.
Right, and so the next question is, what do you do when, especially in a high-rise building or a close quarters condominium? What do you do if you do have a positive COVID-19 resident that hopefully self-reports to the community, right? So what we've done, at least with some of our clients, we've worked out kind of a Q&A that can be worked out with the resident. And let me just walk through what we're suggesting to people, but this may vary depending on the kind of building you are, the kind of construction it is, the kind of demographic you have in the community. But the first question would be to confirm, in fact, that if they are a positive COVID-19, that they indeed are going to self-isolate as directed by the CDC, as directed by your local health department authorities. And by the way, your local health department authorities are very important in this. They're really asserting some jurisdiction and some power here, and along with a lot of good information. So it's not just about the CDC, it's also about your locality. But confirm that they will self-isolate, and then try to find out for how long they are planning to self-isolate. You want to have something on the calendar that indicates that the person up in 2B is coming to the end of their cycle, so that you have some idea of what's going on with that unit. In addition to that, I have found it helpful to suggest to clients that they may ask the resident if they would like to be, or where they would consent to be identified to the community as someone who has this issue. I mean, there's kind of two issues there. On one hand, it may help that person in achieving a successful self-quarantine if they know that they're not going to be bothered by their neighbors coming to their door, right? In addition to that, I'm kind of optimistic when it comes to practicing community association law, that the word community is really supposed to matter in these situations. And then perhaps if the association knows that the person on the third floor is self-isolating, that maybe the other neighbors will help out some. Maybe they'll offer to run errands for them or leave mail at their door or something. I think that, especially in a time now where the nation needs to pull together, what better time for that to happen than in a community association? So ask the resident if they're okay with the board or the association alerting the community in general to their situation, and then ask what the association can do to assist. Can the association leave packages outside their door? Can they bring the mail to the unit? I'm not saying you can make any promises here, because there may be some promises that simply can't be kept because the building doesn't have the kind of service that can provide those tasks. But at least I think you should ask the question, because our goal here is to assure a successful self-quarantine for this person. So why not ask the question? And then whether or not an owner has authorized you to disclose who they are, I do think it makes sense to alert the building as a whole that there is a positive COVID-19 case in the building. And I know that creates some angst with some communities, but I do think that honesty is the best policy in these situations. A building is better off knowing that they have a positive case in the building, so everyone can take the kind of precautions we all should be taking all the time here. And I think if residents find out after the fact that the board knew that there was a positive case in the building and didn't tell anyone, I think that's a bigger problem than simply identifying the fact that there's a positive in the building. And by the way, I've had at least one case so far where there's an owner they're not refusing to self-quarantine as much in their positive case. It's more that they are insisting they have to walk their dog or something, okay? And they're gonna leave periodically. In a situation where the association believes an owner is acting recklessly with respect to this situation, it is appropriate to alert the local health department authorities. There have been a couple of cases around the country where the health department and the police have gotten involved to make sure that a resident was doing the right thing in terms of self-isolation and self-quarantining. And it's not up to the board to do that. I would say it's up to us to alert the appropriate authorities who can do something about that, more so than our board.
And again, that's where if that particular owner is saying, I need to walk my dog, you have a lot of volunteers in your community who are willing to help out and take the dog for a walk. Obviously, you're going to want to sanitize that leash, disinfect the leash, but that's pull on the volunteers. If that's again, how can the association assist in that person quarantining them?
I know in the case I just mentioned, Laurie, the management team actually provided like a little area of fake grass that the dog can actually use in the unit, which is actually what most local health departments have been on the record stating, that having a pet is not a good enough reason to leave your unit, and that there are options for taking care of the pet's business within the unit. And you can buy these contraptions that you can hand off to the owner so that they can carry out the self-quarantine and still have a pet. It's not the greatest solution, admittedly, but these are tough times, and tough solutions are sometimes all we have in front of us.
And hopefully temporarily, very temporary, couple of weeks. All right. Okay, so I think we've
reached, right. I think we've reached the point in the program where we're going to start taking questions, Dawn. Is that right?
Yes, you guys did a great job. Thank you so much. Some of these questions were answered as you guys continued your presentation. However, we do have some really good questions for you. What is the responsibility of an association to leave packages in front of residents' units that have been quarantined?
Well, I think we're in uncharted waters about what the legal obligation of the association is, okay? Is there a duty for the association to do it? I don't think I can cite a case that would suggest that. However, as I just talked about with associations who want to have their residents achieve a successful self-quarantine, I would suggest it's a great business decision for the association to be able to provide a basic service like that, because it will help that resident achieve their self-quarantine, and that makes the entire building safer. So if the association has the staff to do it, or perhaps there can be neighbor volunteers who can assist, and as long as they can do that safely in a way that doesn't harm themselves, I would say it's a great business decision for the association to do it. I'm not saying it's a duty, but if you want the person to stay in their unit, make it easier for them to stay in their unit, right?
Yeah, and it again goes to how can we as the association assist? in your quarantining and keeping, again, the objective is to keep our residents healthy.
Here's another question, and we talked about this right before the call started. Several cities and counties and states have announced shelter-in-place or stay-at-home orders, and they've defined different sectors or workers as essential employees. What do you believe homeowners association condominium managers are categorized as essential employees in most of these stay-at-home orders?
Well, so like any good lawyer answer, we're going to say it depends. I think it's going to depend on the services that particular manager is providing to their community associations. I think it's harder to make an argument that they're not essential when they are coordinating important functions for the community, like we've discussed already. So I think it's a tougher argument to say they're not essential. Certainly that managers that are in high-rise buildings, I would say they are essential. And I think a lot of portfolio managers are essential as well. But there, again, you have to look at the specific state's orders. For some, if you say they're essential, that means they have to show up at work. And the management companies may have taken the position that their employees are going to be working remotely. So we have to be careful in what the implications of putting that determination or making that determination that they're essential. So you're going to need to look at the specific requirements and what the actual functions and duties of that manager are. And I know we talked about at least one state has suggested that if there's a question about it, you can send a letter to the state officials asking that managers be deemed to be essential or clarification on that point. If they've been deemed to be essential, it would be helpful that they have some documentation that they are deemed to be essential, so that if they are pulled over by the authorities, they've got the documentation, whether it's their employer that has deemed them to be an essential. So they, you know, if they are in that situation, they can provide some documentation.
Thank you, Brendan.
I've reviewed 3 or 4 different state executive orders on this, and every one of them seems to have a category that I see fits easily within property management, usually referring to building maintenance or building operations. So I'm thinking that in most states we're going to be fine on that, but you have to look to your locality. Dawn, I know CAI actually has helped in at least one of the jurisdictions ensure that the governor's order actually included that, didn't they?
Yes, and
Yeah.
as we talked about, so some of these stay-at-home orders call for essential workers. Others allow for businesses that are allowed to stay open versus essential workers, and exempt from the stay-at-home order as well. So our legislative action committees are working with states on this issue to make sure that those homeowners association condo managers that are indeed essential qualify under the existing stay-at-home order. We also have on our webpage, caionline.org/coronavirus, there's a tab there for government action. And we have a whole list of the stay-at-home orders, and we're updating that regularly.
Great.
Let's move to the next question. If the governing documents state that the association must charge late fees, does the board have the authority not to charge them for delinquent assessments?
Well, listen, there may be different, this issue may be treated differently depending what state you're in. I happen to be in a place where, to me, if a board, it says they must charge something, if the board decides not to charge something like a late fee and they don't charge it, who's going to sue them? I suppose other owners who will say that the association got a little less income. I've seen communities have this language, but I've seen boards waive late fees in extenuating circumstances or appropriate circumstances, but I never have yet seen liability arise from an association for failing to charge a late fee. I'd say as long as the board puts on the record its rationale, for example, why it may not charge a late fee, for example, a pending horrifying national emergency like we're in right now, I would think the board is pretty well served because they've created a record defending their reasonable business decision. Laurie, maybe California, you guys have a different mindset.
Well, we probably do because we're in California, but that's interesting language. I usually it is discretionary. So as to whether the late fees are imposed or not, but I agree with Brendan, even if there's you must charge late fees, I'm willing to defend that in this time with my association that says, we felt it was in the best interest of the owners to not charge late fees where 50% of our community was laid off or whatever the situation is. So I would feel, good about defending that. And, hopefully the judges would be sympathetic to the homeowners who are laid off and the association choosing not to impose a late fee. I don't love to advise that you don't follow what your governing documents say, but we've got to employ a little bit of common sense here in this situation as well.
Here's a question about common elements. If the board decides to keep a clubhouse or a gym open, are they legally responsible for keeping it clean?
So in most jurisdictions, the association must maintain its common areas in a reasonable, safe condition. Okay, that usually means there's no open, obvious hazards that are going to hurt people. Okay, but I would submit to you that when it comes to a situation like this, where there is, a disease that's spread, it's a tiny virus that's undetectable to the naked eye, there's no way an association could be reasonably expected to keep it free of all disease. Should they keep it clean and sanitary in accordance with normal practice? Of course, but there's no association that can guarantee that there's absolutely no germ, no virus on any surface in anyone's common area. It's just impossible. I don't think there's a legal standard that would be employed by a court in holding them to that kind of a serious standard. So that would be my view of that is, yes, you're required to keep it reasonably safe and clean, but you can't keep it necessarily completely free of all dangers and hazards that are unseen.
Yeah, and one of the things I would say that board really does need to look at, though, is what Brendan talked about at the very beginning. We're talking here about making decisions based on business judgment, and when there are stay-at-home orders and they're closing the beaches and they're closing Disneyland, is it good business judgment to keep common amenities open at this time? So I think that could be looked at as well as another angle, and I think that the board should certainly seek specific advice from their legal counsel as to whether there's an issue with the fiduciary duty in choosing to keep amenities open at this time.
Here's another one, and communities have already been receiving questions about this. I think we all know the answer, but it's about how we message the answer. So if associations are closing their common elements, their pools, their gyms, and other amenities, do the residents get a refund on their assessments because these amenities are closed? Again, we know the answer, but it would be great for you to say the answer. And but how do we nuance the messaging around that?
Well, the answer is no. But I guess the nuancing of the messaging is that the assessments go for more than just keeping these amenities open. They go, I don't know that the insurance premium isn't going to not be due anymore. All the association's expenses are going to continue. Some may increase. We talked about increased janitorial expenses, especially if they are keeping those areas open, and we want to increase the janitorial and the disinfecting protocols. So the association's bills aren't going to stop, and for that reason, the assessments that go to pay those bills need to continue. And I think it is messaging it in that manner, that showing that our expenses are continuing, some are increasing, and the assessments go for more than just keeping the pool open.
And I think one important message too is that a budget is always a planning tool. It is imperfect by its nature. You don't know what's going to happen in any given year. Obviously, we're in a completely unforeseen circumstance, reasonably unforeseen circumstance right now. But in any year, any number of budget items might end up off the mark. So I think for now, the board's best answer is going to be, listen, our budget's our budget. We're not gonna make any decisions about anything like that until the end of the year when we see how all this is shaken out. But no, they don't get a refund, as Laurie mentioned.
Does the board have the authority to pass an emergency resolution to ban short-term rentals so they don't allow visitors in the community during this time?
That is a great question. That is one I have not heard yet. And as Laurie mentioned, the lawyer answer, and so many times we have to give those. A board's authority to act in an emergency or otherwise is so driven by the governing documents, the bylaws for the community. Some boards have very broad authority for things like that. Others have far more restrictive authority. I'd like to think that emergencies call for stretching of that when the time comes, but it's hard to give that answer without reviewing not just the governing documents, but also the state law in which this association exists. So I'd say that we really can't answer that without looking hard at their actual documents. Laurie?
Or the snarky answer is people shouldn't be taking vacations right now.
well, true enough. But hopefully those documents have enough room to maneuver on this that they can do it. But you know, you have to talk to the association's lawyer about whether it's well advised given those documents.
Yeah, I agree with Brendan. It's going to depend on the documents and the situation. I'm a little surprised to hear that associations might be having issues with short-term rentals. I was being snarky, but not really. I mean, people are supposed to be staying at home. So it's interesting that there's still, I guess, a market for short-term rental that's occurring right now. So
here's a question from a community association manager. Their board is refusing to adhere to CDC guidelines and will not close facilities. How should the manager address that with the board? And is there a liability that the board then has to the residents and families regarding exposure to the coronavirus?
Yeah, so again, I think it goes to the business judgment of the board. Are they exercising good business judgment in keeping those facilities open? Has the manager suggested they consult with legal counsel on that point? And you know, I would say that the manager, to the extent they could suggest or that perhaps we seek an opinion from legal counsel as to what we should be doing in response to the coronavirus and keeping these amenities open might help to move the needle.
Well, I think sometimes, I mean, it may be that the manager's sitting with the board and walking through these issues and is not making headway, but I found that if a manager or a management company feels strongly about a particular issue, particularly if it's a health and safety issue, that if they put something, they formalize it, they put it in writing, not just an email, right? A signed letter that says, this is our recommendation for the following reasons, and sends it to the board, that sometimes can have some more impact than just stating it at a meeting, because now the board has it in writing. I mean, and the management company, listen, Laurie and I counsel associations, not necessarily management companies. But I understand there are situations where the managing company may want to protect itself. And I think putting that in writing to that board is probably the best thing they can do as a management company to protect themselves. And at the same time, convey an important pressing message to the board about a business judgment they need to make.
And I've seen a lot of letters from heads of management companies. These are employers that have employees, and they do not want to put their employees at risk. Where they've taken a position that their managers are not going to be attending meetings in person. So that's, if that's the situation as well, if the board's insisting on meeting in person and the management companies are, protecting their employees and saying, we're going to attend telephonically, virtually, et cetera, that's another way to protect the manager in that situation.
Can an association board suspend review of architectural requests?
Well, architecture requests, most of those are driven by governing documents as well. Now, in so many documents, I'm sure Laurie has seen this as well, there's a time period during which a board must review architecture requests. And it may be the board has some discretion to put those on hiatus for the time being, given the situation that the country is facing. But again, they're going to have to look to the locality and their governing documents as well. I hate to give that answer so often in these kinds of webinars, but the reality is some things can't be answered at kind of the national level. It's going to depend how that state's laws are written and how the governing documents are written. So that's what I'd say on that one. Laurie?
Yeah, we have a few architectural matter solar installations that have time periods under the law. The law says you have to approve those applications within a certain period of time. So I think that is, again, a question where those communities are going to need to consult with legal counsel. Maybe it's, if they can get together without, getting together, if they can get together virtually and review the application and make a determination in the time period, but it may be, asking the owner to wait a little bit of time before bringing the contractor on site to actually do the work.
I'd say also, Laurie, in the best possible world, we should be working together on these things, right? An owner who was filing an application to make change to their home, you would hope that they would see the situation the board is in, the association's in, and their contractor is in, and perhaps they can be convinced to withdraw the application or put it on hold for a while. That might be a good practical solution in the short run, rather than forcing boards to make difficult decisions virtually while they're facing this kind of crisis point in their existence.
Yeah, and I could see too where, if the board needed to consult with maybe an architect or somebody, the more people were getting involved and having to be on site this is not the time to do that. So I agree. Yeah, maybe going back to the owner and saying, would you mind taking your application back and resubmitting it when, in another 30 days, or let's see what the time frame is. Again, the message is we're trying to protect the health of our community.
Which I think is the importance of the question, is the access of the non-essential individuals coming into the community, right? The business partners who may be non-essential.
Yeah, they may not be able to get that solar installer on site,
right,
if they're not essential.
What is the, if an association chooses to close their pool, but they have a resident who has, a disability and needs to use that pool for exercise purposes, and that individual makes a request to the association to use that pool, though the pool is closed, open and running, but closed, what is the association's obligation to respond? Well, they're obligated to respond. What's their obligated response?
Right.
Yeah, so I mean, this is a situation where you've got the competing interests. You've got the person with a disability that, I think, again, it's going to be a case-by-case situation, and reviewing it. Is their water therapy vital to their disability? That may be, you may have to grant an accommodation to that, but the competing interest is, again, keeping the community safe. So if that person is allowed to use the common facilities, then I think you're going to have to look into, again, understanding when are they going to be there, maybe have set times that they're going to be there so that you can prepare and have extra disinfecting protocols taking place afterwards, before even. Certainly having that resident understand that they are using the facility at their risk as well, because the purpose of closing the facility is to prevent transmission of the disease, and that if they're using the facility, like Brendan said, we can't guarantee that it's going to be virus free. So having some kind of acknowledgement of that person who's using the amenity. But I'm going to look at it very carefully, I think, in this time.
Yeah, the fair housing standard for accommodation is going to be about whether there's an unreasonable burden imposed on the association by the request. And as Laurie mentioned, all those factors go into whether it's an unreasonable burden to either open the pool so it can be done, or whether the pool can be done safely, what kind of costs are going to be incurred as a result of that use of the pool. And all that will go into a very difficult but hopefully measured analysis of whether unreasonable burden exists. It could be that they've got to do it if it's really not that big an issue, or it could be that the answer might be no in these trying times.
Or not at this time.
So there's a manager posing a question. This manager manages an active adult community, and most of the households, or a good portion of the households in the community, involve individual homeowners, just solo homeowners, people living on their own. What is the board's legal obligation, if any, to do wellness checks on those individuals?
I don't think there's an affirmative obligation for the board to do that. I mean, I know that right now our seniors are probably our most vulnerable group demographically from this COVID-19 mess that we're all in. But I don't think that the association's mandate extends to ensuring the personal health of every single of the residents, even in a 55 and older community. Of course, I represent several of those kind of communities, and it's important that the association continue to push information out, that they encourage neighbors to look out for one another, that they understand the protocols that are being imposed on them, make it easy for them to quarantine if they need to. But I don't think the law would extend to the association this extra obligation of making sure everyone is okay at all times, even in a situation like we are right now. I think it would fall mostly.
So if an association feels like they have a moral obligation and they want to do that, do they then expose themselves to any liability with that?
Well, there are ways to do that, and that's a great question, Dawn. It's for example, neighborhood watch. A lot of communities have neighborhood watch. Our typical advice on neighborhood watch is not to have it be done by the association, but by a group of volunteer neighbors, homeowner neighbors, who will then organize themselves. Maybe they use the association as a platform in the sense that they will show up at the association meetings. But I would say if someone wants to set up a wellness check group or of some type, the association can allow the clubhouse to be used for them to coalesce and organize. But I'd say again that it should not be done as an association function.
Yeah, I agree with Brendan. I don't think there's a legal obligation on the association to perform those wellness checks. And, you know, there is some concern about liability. If you don't have a duty and you take it on, are you then exposing yourself to liability? So I agree. I don't think it should be an association function. I don't think it's legally an association function. But whether, and again, in those communities, they have a lot of active committees, and there would be committees perhaps that could help facilitate that. And CAI has, I love the volunteer card that's on the CAI website, where you can print these cards for, hey, I'm a neighbor, I need help, or, you know, I'm willing to help. So, you know, perhaps utilizing that as more of a grassroots effort and not as an association function.
We have just a couple of minutes and I have two additional questions and then we'll wrap up. One is related to enforcement of covenants, violations of covenants. So I've seen some news articles that people are encouraging residents to put their Christmas lights up because it makes people happy. So clearly in March, that would likely fall outside of a covenant of an association. What are your thoughts on associations enforcing violations of covenant infractions?
Yeah, I think in my community, I've heard at 7 o'clock they're ringing bells, like people are ringing bells or something. I haven't heard them yet, but supposedly that's happening. You know, I think something like that is, you know, what is it harming the community, especially at a time like this? We're trying to build community, and if it's allowing people to ring bells for 10 minutes at 7 o'clock at night or whatever, or have their lights on, I think the communities could certainly consider some leniency, but I think it is going to be a community to community decision and what the impact is. You do have more people working from home. You have homeschooling, you have kids home. So you got to balance a nuisance issue. I actually suspect maybe we're going to be asked to write more cease and desist letters because people are home and there might be some more violations that are reported. So, you know, I think the communities are going to have to evaluate that amongst themselves. If there's this Christmas light thing, maybe you employ certain hours and say we're granting a temporary variance to allowing Christmas lights in March, but they need to be off by 9 p.m. or whatever the community decides.
I mean, listen, I think community associations, we're all part of the bigger puzzle of a problem the nation is experiencing as a whole now. I know one of the primary reasons we exist is for covenant enforcement. But as Laurie said a couple of minutes ago, it's about common sense and it's about community spirit. I think there are times when a board can suspend some of the classic steps they might normally take because of these extenuating circumstances. And I can't imagine there'd be a court in the world that would penalize an association that elected to have a couple of months where they let some of these rules go. I'm not supposed to say that as a condo lawyer, but I'm saying it right now because of the situation we're in.
So I think maybe it's different, like installing a shed violation versus putting up a flag or Christmas lights or something like that.
Anything to help community spirit right now. I mean, a lot of people are afraid right now.
Yeah.
And why put your association in, as an obstacle to something that could help quell people's fears? This is a time for us to rise above all that.
And it's a time to build community. And if that's going to build community to gain cooperation on some of these other things, steps that associations are taking, like closing the amenities, if that might help with those hard decisions that the boards are trying to make.
Great point. Final question is regarding annual meetings. Say an association has scheduled their annual meeting, they've sent out their proxies, and they now have to cancel their annual meeting, postpone their annual meeting. Are those proxies still valid? Postpone, right. Are those proxies still valid? What do you guys think? This is our last question.
Well, it depends what's on the proxy. So some proxies actually affirmatively state that they are good for any postponement or recessed version of the meeting. But I tell you, it's one thing to, postpone the meeting a week or two, or reset or show up. You don't have a quorum. You recess the meeting to another date, and then those proxies almost certainly would be good because it's really the same meeting. But if you're postponing for a significant amount of time, I'd say you're probably better served by having sending out new proxies and new notices. Because it sounds more like a meeting cancellation than a postponement. But really, if the proxy language has enough in there, maybe the proxy can be used at the future meeting.
Yeah, I agree. It's going to depend on what the proxy says. If the postponement is short, and I hopefully the postponement's maybe 30 days, 60 days. You don't want to have to necessarily incur another mailing and expenses with that. So I would again examine it and try to find a way to make them valid.
Excellent, thank you. I'm going to give a few pieces of housekeeping information, then I'm going to toss it back to each of you for some final comments, and then we'll be able to wrap that up. Thank you so much, Laurie and Brendan. Really, really appreciate your time today. A couple of housekeeping pieces. If you go to the handouts section of this webinar, you can find the PowerPoint slide deck and you can download that. You will also find an audio recording of this presentation. It will be sent to you after the closing of the webinar, about an hour after the closing of the webinar. Anyone who is interested in continuing education, you received 1 hour for this. CAI will automatically put it on your account, your CAI account. And I'd like to encourage you to continue the conversation in the days to come. Go to CAI's Exchange for our community, our online community, to continue to post questions and share resources, share information with others, and stay up to date on stay-at-home orders, government actions, additional frequently asked questions, and resources on our website at caionline.org/coronavirus. I will, as promised, I'm going to send it back to you, Brendan and Laurie, for some final comments, and then we will wrap the webinar. Thanks so much again for being here.
Well, I'm happy to say, first of all, thank you all for tuning in, for caring enough to tune in to listen to us. Obviously, you're good volunteers, those directors who are on the call, or you're good managers for staying on top of all this. One thing to remember in all this, with all the angst and the stress and the anxiety, is don't forget about your own health, about not just staying clear of the virus, but also your mental health. I have so many of my board members are so stressed right now because they feel like the weight of the world is on their shoulders and their buildings and their communities. Don't forget that whole neighborliness and the spirit that community associations are supposed to exist in. That's incredibly important right now. So stay positive. We're going to get through this. Your association is going to survive. Associations don't go anywhere. We're all going to be here. So just do the best you can, use your experts, and stay positive.
Yeah, and again, thank you for, I agree with what Brendan said. Thank you for volunteering your time to educate yourself, not only now, but in serving your communities. And take advantage of the resources out there. CAI has excellent resources. The states and localities have, every website I've gone to has a page on COVID-19. So there's a lot of information out there. That's what we're here for. Your experts, the people you work with day in, day out, they're here. We're here to help each other. And yes, take care of yourselves and your families. Everybody's under extra stress right now. So definitely take care of yourself.
And Dawn, keep up the good work at CAI. These kind of presentations are really helpful for people, I think.
Definitely.
Our pleasure. We are at the service of our members, and we're proud and privileged to do that. So thank you. Brendan, Laurie, everyone else on the call, thank you so much for being here. Stay healthy, be well, and keep in touch. Thank you.
Bye now.
Bye.